You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 124, Dead Inventors, Inventors in Comas, and Minors who can file a patent application. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's DIAMENT patentlaw.com, or call me at 424-281-0162. Most of the time, an inventor will come to me and want to patent her invention. The regular forms apply, and if you're a company, you have employees that invent something, and we have forms that the inventors have to sign, as well as a company officer that will have to sign. That's all normal stuff, but occasionally some interesting things come up about inventorship and you have to know what to do. I'm going to talk about a few situations where the inventorship can get a little bit tricky, and this is with dead people, incapacitated people, such as if you're in a coma, and minors. The minors, not people that are digging for gold. I'm talking about people under 18. Why might this be an issue? Well, one thing you have to do when you file an application is that you have to sign a declaration of inventorship, which is just a one-page form where you declare that you are the inventor of what you're filing an application for. But if you're a parent, you probably know that your kids aren't allowed to sign things, and you have to sign things for them on their behalf all the time. So what do you do with this declaration of inventorship that the inventor has to sign? You can imagine there might be two possibilities. One is that the parent signs on behalf of the minor, and the other is that the minor signs herself. And the answer for this one is, drumroll please, the minor can sign herself. This is found in MPEP section 409, where it says a minor may execute an oath or declaration under 37 CFR 1.63 as long as the minor is competent to sign, which is that he or she understands what the document is about that they're signing. A legal representative is not required to execute an oath or declaration on a minor's behalf. But there is another issue. If you're the parent of a minor and you want an attorney to file a patent on your kid's behalf, like any patent application, you have to give power of attorney to the attorney to file on your kid's behalf. If that's the case, the power of attorney has to be signed by the parent on behalf of the kid. I tried to see if there's a form for this on the Patent Office website. The normal power of attorney form is PTO AIA 82, but I couldn't find any box to check on that form. There's a box where you write the applicant's name, and then 4 boxes underneath there, and you're supposed to check one. And one is if you're the inventor, another is a legal representative of a deceased or legally incapacitated inventor, another box is an assignee or person to whom the inventor is under an obligation to assign, and a box for a person who shows otherwise sufficient proprietary interest. None of these really fit the case of a minor. A minor is not legally incapacitated. You might think that the parent is the legal representative of the minor, but above all those checkboxes, you have to write the applicant's name. And if the applicant is the child, and you put the child's name in, and then you checkbox that that's the legal representative, then you're just saying that the child is the legal representative of herself, and that doesn't seem to make any sense to me. So I think the best thing to do is to make your own power of attorney. It can be pretty short. It should say something like, as a parent of minor child, and you put in your child's name, the sole inventor of the subject matter that is claimed, you put in your own name, hereby appoint the following practitioners to prosecute and conduct business at the Patent and Trademark Office under, and then the customer number or the patent attorney number. Really, your patent attorney should be doing this all for you. Then you sign, you put your name down. If you're the parent, if you want to talk to the patent office on your kid's behalf, you might designate yourself and not even try to go through an attorney. I've actually never seen this done. I'm not 100% sure what the patent office does if the examiner wants to talk to the inventor and the parent wants to talk to the examiner instead. Maybe the examiner will talk to the parent no matter what, but maybe they'll need a form. I've actually never seen this done. Maybe just having a one-page write-up saying that you're the parent is all the patent office needs. I'm actually not sure. But if you want to give me power of attorney to speak to the examiner, then I, as the attorney, will need a power of attorney from the parents signed on behalf of the child inventor. But the declaration can be signed by the child inventor herself. Now, if that person really can't sign the declaration because they don't understand it, then you probably have to sign the form on what's called a substitute statement, which I talk about later. The other issue is with a deceased person. Let's say you come up with an invention and then you die. Your wife wants to patent the invention that you invented, but she's not the inventor, so she can't sign the declaration herself. The rules state that if the inventor is dead, insane, or otherwise legally incapacitated, refuses to execute an application, or cannot be found, and the application may be made by someone other than the inventor under these various rules under 37 CFR. If the inventor is dead, the legal representative of the deceased inventor may make the necessary oath or declaration and apply for and obtain a patent. This is found in 37 CFR 1.42. There's a form called PTO-SB AIA02, and it's called the Substitute Statement in lieu of an oath or declaration for utility or design patent application. Lots of words there, but for short, people just call it the substitute statement. This is what's used instead of the normal declaration, which is AIA-SB 01. In the substitute statement, you put in the name of the inventor. Actually, you put in the name of the invention, the application number, and also the name of the inventor. Then you have to do a checkbox in the form on what your relationship is to the actual inventor. You could be the legal representative for a deceased or legally incapacitated inventor, an assignee, a person whom the inventor is obligated, under an obligation to assign, a person who otherwise shows sufficient proprietary interest, or a joint inventor. Then you have more checkboxes. Of course, these forms just love checkboxes there. And you have to basically check the checkbox on why the inventor isn't signing himself. And one is that the inventor is deceased. Another checkbox is that the inventor is under legal incapacity. Maybe that's a coma or something like that. Another box is that the inventor can't be found. And another is that the inventor has refused to execute the oath or declaration. Now, you might be thinking, what kind of situation is it where the inventor can't be found or refuses to sign a declaration and they're filing a patent application? And that situation may happen if you're a company, the inventor quit and refuses to sign the declaration because he's just pissed off at the company. But legally, you have to put all inventors' names down on the patent application. So if it comes down to an ex-employee just refusing to sign anything or has disappeared, that's when you have to do this kind of document called a substitute statement. Then there are two more boxes where it asks if there are joint inventors. You have to check that an application datasheet has been filed, naming all of the inventive entities, or if it hasn't been filed, there is a substitute statement called a supplemental sheet, which is form PTO AIA 11, and then you just have to fill out that sheet. It's just one page where you list the names of the joint inventors and addresses. It's not a big deal. I have to say I've been a practicing patent attorney for over 12 years. I've never filled out this form once. Maybe I'm just lucky. Hopefully, if you're a company, you won't have to do it, but it's not too difficult. It's just a couple pages, and all the forms are on the Patent Office website. For businesses, one lesson you should get from this is that you should have all the inventors sign the declaration of inventorship right away while they're still happy at your company, because you don't want to file an application without the declarations and then months later tell everyone they need to sign some documents, and half the inventors are gone and you have to spend time looking for them or dealing with inventors that just want to make life difficult for you and refuse to sign. But there are remedies to this that the Patent Office has, but it's better and easier to just have the inventor sign the one-page declaration early on so you don't have to deal with it and you just turn it all in at the time of filing the initial application. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.